Hello, my name is Irwin Ironstone. Ironstone is English for Eisenstein. I'm not a lawyer. This short video will discuss why video and/or audio recording should be available to the public. Currently, it's not. And this is a strange thing. In any case, based on public demands, many police departments have been required to wear cameras. Judges who have very little accountability should also be required to have cameras or audio recordings done in court. Cameras and audio recordings may result in gathering the best available evidence. That doesn't happen now. And we'll go into that in a little bit. In any case, going way back in history, in 1884, Oliver Wendell Holmes, who wasn't at that point a justice of the U.S. Supreme Court, but of the Massachusetts Supreme Court, made a decision in a case called Cowley versus Pulsifer, and it's 137 Mass 392. That's special language for lawyers. It identifies how to find a case. He said that members of the public enjoy a right of access to civil trials. This right, he said, is rooted in the democratic principles. He said, it is desirable that the trial of civil causes should take place under the public eye, not because of the controversies of one citizen with another are of public concern, but because it is the highest moment that those who administer justice should always act under the sense of public responsibility, and that every citizen should be able to satisfy himself with his own eyes as to the mode in which a public duty is performed. Right now, it's been amazing. Because of the COVID virus, courts have been closed, except they're now using cameras and audio recording in order to hear motions and possibly even to hear trials. We don't know about that yet. In any case, I've always wondered why, cameras at this point are tiny. They're about that big. You can have one or two cameras running in court concurrently. You have software called Zoom and some of the others that can capture multiple people on a single digital recording. Okay, I'm now going into something else, which is a case of, I think it was from Learned Hand. It's something that I guess happened in around 1932, and it's called the T.J. Hooper. And the T.J. Hooper was an interesting case. What happened is a tugboat in New York was carrying barges across, I guess it must have been the Atlantic, and it was caught up in a storm, and the barges and the coal that was on the barges sunk to the bottom of the sea. Now, people who owned the coal and barges were not very happy at all. So they sued the owners of the T.J. Hooper. And the T.J. Hooper said, we're not required to have radios to tell us what the weather is going to be. But there was one company, one tugboat company, that did have radios and could get weather reports. If the T.J. Hooper had used a radio, they would have been able to get a weather report and probably wouldn't have tried to cross the Atlantic between New Jersey and New York. Okay, out of this came an interesting legal principle. The legal principle says that if in fact there are technical innovations around that would help you do your job and make it safer for the people who you service, they should be used. Cameras have been used in some courts, but many federal courts, many state courts at this point don't allow cameras. They feel they're intrusive. In fact, the very Supreme Court of our country doesn't allow cameras in the courts, but they do allow audio recording. And there are lots of reasons that audio recording should be used. I'm just glancing through my notes on the T.J. Hooper. In other words, the Hooper tried to defend themselves, saying it's not required by industry to have a radio. But if you had gotten the radio and hadn't tried to take the barge across the Atlantic, it wouldn't have sunk. And Judge Learned Hand wrote a decision, I believe it was in 1932 or 1932, and that decision is valid. And someone asks, does that apply to the legal profession also? And my question is, why doesn't it? It should apply, because without it, the public is not being served. They can't see what's going on in court. There's no way for them to go to court if they work during the day, which most of us do. So if you had a recording, either a video or an audio, there are things that would show up that aren't showing up in our current court system. Although there's no custom suggesting that tugboats be equipped with radios, the court found that there are precautions so imperative, so important, that even the universal disregard will not excuse their omission. So he's saying, you guys should require radios, otherwise you're going to be responsible if you get caught in a storm. Okay, now, the T.J. Hooper is taught in just about every law school in a class called torts, which is civil damages. And one wonders why we've been going on for so many years without audio recording or without cameras in the court. Okay, that's where I'm going to stop here. I just raised two issues. One is that we should be able to see what goes on, and we're currently not. And there are ways that people can and should be able to have access to the audio recording or to the video recording. Now, I'm going to now give another little suggestion. Why do we need either audio or video in court? The reason is the transcripts aren't sufficient. The transcribers don't always hear things, and they leave out parts that they should be recording. Not only do they leave out, but things that happen, for example, if a judge or a lawyer says, "Judge, he's lying," it's very different on a transcript than it would be if you heard, "Judge, he's lying." And you have tone, You have interruptions. You have a volume that never appear on a transcript. If I were a lawyer, and I almost got there, I passed the bar, but they said that, it depends on which bar, they said that I had acted improperly in the past. They ain't seen nothing yet. They basically was saying, you're going to criticize the bar, and you're going to criticize the judiciary. And the question is, they're not policing their own. The judiciary has had hundreds of complaints placed, and hardly any of them, especially at the federal level, have gone to hearings, because what happens is judges don't rat out other judges for misbehavior unless it's really so flagrant, and the newspapers haven't heard about it, which is probably the other issue, that members who are lawyers and members who are judges will very rarely criticize the system. Okay, I was going to talk about contempt hearing. That's when the judge comes down on someone, and that's in a case called In Re Little. It's a U.S. Supreme Court case, and it was in 1972. And it was a contempt hearing. And what happened is, it was appealed all the way up to the U.S. Supreme Court. And they said that if someone is defending himself, he should have the same rights and privileges, effectively, as lawyers to make very strong arguments against the legal system. Now, what happened is, there are two parts of it. One was written for the whole court, that's called a per curiam. But then there was something else that was written by the Chief Justice, at that point, Justice Berger. And what he said is, I agree with the court's disposition of the case, but something more needs to be said. A contempt holding depends in a very special way on the setting and such elusive factors as the tone of voice, the facial expressions, and the physical gestures of the person who they're trying to hold in contempt. These cannot be dealt with except on a full ventilation of the facts. Those present often have a totally different impression of the events from what would appear even in a faithful transcript of the record. Some measures of the flavor of what really occurred in this episode, and it was a contempt hearing, how his words impressed those present, may be gleaned from the events and utterances described in the court's per curiam decision. In summary, courts should make videos and audio recordings available to the public and also for the appellate courts, so the courts can be observed, the lower courts. Transcripts are just not sufficient because they do not describe prejudices and manners of nonverbal communications in court. They say that nonverbal communications can account for 50 to 70%, sometimes more, of the communications between a person who speaks in court and what others hear. And at that point, I basically read and raised three issues. Our courts are obsolete. Justice isn't really justice unless you have independent reporters, because right now judges allow people who are transcribers who make errors, and very rarely do the transcribers say, the judge raised his voice. The judge told someone to sit down. How did he tell him to sit down? nothing goes on the transcript, nothing was said. But that judge was being a bully and was controlling someone. Now, the next part, I was going to go over parts of a trial related to a judge, Jeffry Ashton, who is a judge on the Florida 9th Circuit in Orange County. And I was going to also go over some of the things that a lawyer said. Sometimes he said something about me. And let me just give, first of all, I think the lawyer misstated information to the court. Not only did he misstate information, he could have sworn on a pack of Bibles, but doesn't have to, because as an officer of the court, he's supposed to be telling the truth. Ooh, what a lie! Okay, in any case, what happened with Jeffry Ashton, he used to be a district attorney in Florida, lost a race, and a few years later, after he said, I don't want to get into any public office, lo and behold, he ran for a judgeship and he won. I don't know who contributed to his campaign. I don't have the time to make that determination, but he won. In any case, I have a friend who sued an insurance company. And that insurance company has, well, it's Florida Farm Bureau Insurance Company. And they also instruct their lawyers, I assume, or their lawyers instruct them how they can beat paying insurance to the average person unless that person gets a lawyer and has deep pockets. Because if you don't have deep pockets, there are lots of things that you can't pay for in a court case. It's very difficult to pay for experts who courts require. It's very difficult to pay for transcripts that courts require. It's very difficult to go through binders and binders of information that the other side may send at you. In any case, this case was before Jeffry Ashton, and like all judges, he says, I'm familiar with all of the facts of the case. And I would say he really wasn't familiar with all, but relied on a lawyer to say things to him, and that lawyer misstated lots of information. Okay, I'm going to have just some of the things. First of all, Matthew Scarborough, the attorney for Florida Farm Bureau, said, and I'm reading only parts of a transcript, I haven't had any meaningful discovery whatsoever which had been intentional, which Judge Kest found to be intentional. My friend had given him about 3,000 pages of information that the prior judge had requested. She also gave him the names of current doctors, and in a prior hearing, which is called an examination under oath, she gave him another 1,500 pages. It had her medical reports, it had cases that she was involved in the past, and here's Matthew Scarborough saying, she hasn't given me whatever which has been intentional. No meaningful discovery. Yet, in his list of exhibitions, he included 6 pages of medical information, people that she went to. He doesn't consider that meaningful discovery. On top of it, what he says is, I have to tell this court, as an officer of the court, this gentleman who may be listening on the phone, I don't know, he said Mr. Weinstein or Eisenstein, has been told by the court he should not be involved. He's talking about me. I have read lines indicating where he is writing comments on these documents and is apparently still filing them with this court. He is not a lawyer, and I know the Florida bar is investigating him. He said that about me. First of all, I have never filed except those things that reflect me. What I don't like is when a court or lawyers bring up my name and don't tell me about it because I'm not someone who's, quote, a third party. And this raises issues as to when lawyers can raise issues about someone who's not a party without telling them. Because what he did is he lied. I never sent papers into the court as it related to Sarah Grimes. And what I can say is this: I know Mr. Scarborough lied. In one instance, when the party was supposed to show up for a deposition, she went to the place and they wouldn't let her in because she said her son possibly has COVID virus. Because I was with her, they threw me out also. What did Mr. Scarborough do? He asked for sanctions because she didn't show up for a deposition. Can you imagine the nerve? He never withdrew those sanctions. He never had them heard in court. But every time you file something, it goes in and remains in a court file. I don't know if Judge Ashton was aware of that, but I was there, and I was at the place where the deposition was supposed to be heard. He also played some other dirty tricks. What he did is he subpoenaed me to be a witness. Why did he do that? I can't say because I'm not the one who did it, but I could guess. He did it because once you're a witness, he can ask that you not be allowed to hear a deposition, and if the court case went to trial, you would have to be sequestered. You would have to leave the courtroom until it was your turn to testify. That's one of the legal dirty tricks, and I'm sure Judge Ashton knows about this and probably would have let it go because you have an attorney who's been practicing for 20 years. I noticed in the transcript there were other things where Judge Ashton raised his voice, allowed the defendants to submit papers hours before the hearing without notifying the party whose hearing it was. They also handed about 700 pages, and they gave the judge a copy in a loose leaf and delivered it, I guess, like 3 or 4 days before they delivered the entire thing to the plaintiff, which, again, Judge Ashton set up 2 sets of rules, one for attorneys and one for those people who are defending their own cases. He should be ashamed of himself, and he shouldn't be on the bench if that's the way he acts. Thank you.